All right, back to the story now. Judgment has been reserved in the Labour Court in the case brought by worker unions Numsa and the SA Cabin Crew Association against South African Airlines or Airways. Michael Apple is following the story for us. He joins us now live. So, Mike, a Zoom court application was heard this morning between the unions and SAA. In a nutshell, what relief do the unions actually want and what arguments do they put forward today?
That's right, Shahan. This Zoom court application was heard at about 10. It went on for about 2 hours. Essentially, the unions say they want no job losses at this stage, not at least until a business plan has been put on the table by the business rescue practitioners, the BRPs. They're saying that any retrenchment which was announced, Section 189 process by the BRPs back in early March, that was premature, as you cannot announce retrenchments or a plan for what to do with the national carrier unless you actually put that plan on the place. So you can't proceed with these retrenchments or voluntary severance packages until you have a plan on the table. But let's listen into Pagamile Hlubi-Majola, who's Numsa's spokesperson. She sent out a statement after the court application.
We want the Labour Court to block any retrenchments from happening at SAA. This is because we believe that the entire Section 189 process, which was started by the business rescue practitioners in March, is unlawful on the basis that they have not yet delivered on a business rescue plan, which is what is demanded by the Companies Act. In our application, we make it very clear that in terms of the Companies Act, they cannot take any decisive steps in relation to restructuring. They cannot negotiate packages, retrenchment packages, when they don't have a plan to guide them.
So what are SAA and the business rescue practitioners actually arguing?
So as you heard there, the unions are saying you cannot announce any retrenchments unless you have a business plan on the table. I'm going to read directly from SAA's court papers. Just bear with me here. And this is what they counter. They say there's nothing in Section 136 of the Companies Act which provides that dismissals or changing the operational requirements of a business is prevented or outlawed. They say that currently there's only 2 options available to SAA: an orderly winding down or complete liquidation. Now, the orderly winding down would involve the retrenchments. They say that offering all employees a voluntary severance package and the only other alternative to that is compulsory retrenchments for operational reasons or complete liquidation. There is an interesting line in their court papers. This is SAA saying that they appealed to the Labour Court not to make itself party to a socio-political agenda. I thought that was interesting. And the alternative that was put forward by the unions was that they want to be part of a training layoff scheme. SAA says that they and trade unions will apply to the Department of Labour and Employment, to the CCMA, and SAA will participate in a training layoff scheme. So they're saying that that argument is null and void. Judgment reserved. Hopefully the judge will be able to send something out before the end of the evening or early tomorrow.
All right. Appreciate that. Michael Apple following that story for us.